I can see how those isolated, and I don't know why you're making those faces to me, Judge. You can.
I'm not
agree
making,
with
first
me.
of all, stop. One, I'm not making any faces. Number two, I'm looking at you and listening to your argument, counsel.
I noted facial expressions, Judge. Like
Well,
you
your
already
notation
don't
is
agree.
incorrect. You may continue with your argument.
If it was an
Address the court.
I mean, no, that's what I've said. So if you all, I'm not proceeding without Attorney Sawyer's being here because technically that is her client. And I haven't received a motion to withdraw.
Have, and it's on file.
It hasn't been signed.
The order, you're correct. The motion has been signed by Ms. Sawyers. The order has not been signed, but there's a YouTube video in which your court said that as soon as Ms. Aaron reappeared, you would sign the order. She's here. So we're requesting that you sign the order.
Ms. Sawyer needs to be here. Tell you, my salary is paid by the taxpayers. And guess what? If we need to be here on Saturday, I know nobody has anything to do. I will be here on Saturday. So we're going to get it done.
Judge, if I may, I'm actually, I've got a vacation notice on file. I have non-refundable tickets leaving on Saturday.
Oh, where are you headed?
I'm going to Florida. I'm going on a cruise in Florida.
Let me just tell you, you know what? I've heard so many bad things about cruises.
I don't
I
want to
may
go, Judge.
I may be saving your life.
My wife's making me go, Judge. She'll kill me.
Your wife is making
She
you
is
go.
making me. I'll leave it up for the record.
Oh, I can't even believe you would say, let's put that on the record. He
I'll
says
put it on
his
the
wife
record.
was making him
I'll
go.
put it on the record. She won't.
Oh, let me just
She is in a jury trial for several days. So you're saying Miss Aaron is going to
have a seat.
and
Have a seat. Thank
Okay.
you. All right, so I'm going to proceed with this hearing. Excuse me, I don't understand the attitude. Have a seat. I will take your matter up. I was explaining to you what the issues were. I don't know why people don't understand what I'm saying. I've explained to you what the issues are. You see these attorneys sitting here. I was giving you all opportunity to speak to her so you can understand what the court's issues are. That's where we are.
Judge,
And then I'm going to take this hearing up and then we'll continue with your matter.
I'm not the court-appointed attorney, as you've already mentioned. So
No,
I'll
you're not.
contact Ms. Sawyers.
Thank you.
Understanding of it, there was a jury trial setting in November and December, but those were actually settings for bond motions. So I don't know that they're actually true trial settings, Your Honor.
We're here today for a jury trial.
And I understand, and I did approach the court yesterday with the motion for continuance.
Yeah, and I was not hearing that.
Respectfully, every time we come to court, we lose an entire day of work ourselves too. This is not typical of most of the courts in this county.
Oh, yeah, it is very typical.
It's not.
Yes, it is.
You can say that, Judge, but I practice in
And
the
say
courts.
And it very is typical because every attorney that's here has a case that's set for jury trial.
Notice and hearing, and then.
You can recall your witness.
Say again?
You can recall your witness state.
So the rest of the objection is notice and hearing, and then procedural compliance.
State you can call your witness.
So met the objection with regard to procedural.
That would be
compliance,
overruled.
notice and hearing. There, that's the
You can call. Oh, well, they've sent a deputy from misdemeanor court to escort Mr. Cox down to misdemeanor court. And I know it's not the deputy's fault. I don't want to make your job any more difficult than it is, but they've sent her up here to take him to misdemeanor court, where the range of punishment goes as high as 1 year at the Bexar County Jail, where we're dealing with the case here, where he's charged with burglary, which the range of punishment is potentially 20 years in prison, but they want him in misdemeanor court. This is the last time, and I want all the attorneys to go forth. This is the last time that this court will be given any type of leeway for people to be out of county in misdemeanor courts, out of county in other courts when you have a jury trial or a bench trial in district court. Unless there's some evidence where he should have a motion for new trial.
All right,
Not
that's
gonna-
correct, Judge. So I filed a motion to withdraw the plea, and I've also filed a verified motion to recuse.
All right, I don't have the motion to withdraw before me.
I have copies. So
And
that's
you
why
want to
I'm-
withdraw.
No, I'm not asking to withdraw as his lawyer. I'm asking for the court to be recused.
All right. Well, what I can tell you is I'm not reconsidering any sentencing. And if you want a motion to recuse, another judge will have to hear that.
That's correct, Judge. So I'm asking that it be, and I know the state's asking for a few more days to properly.
Oh, there's
prepare.
nothing for me to do on the case once you file that. So that the record can be clear, The court is aware of who can and cannot appear by Zoom and who the court gave permission to appear by Zoom and not by Zoom. So there's no need to come in hot with, you told her she could appear by Zoom. I already know that it's on the docket sheet. The Zoom link changes, and it changes every single month. The clerks in the back do not have the Zoom link. Once they come out here, that's when they're given the Zoom link. So where are we on discovery?
That he would be granted deferred adjudication. And, he wants to move on with his life. He wants to start probation. He understands that should the court grant him probation, he'll have to be here for 45 days, right? You understand? You understand? And that if he wants his probation to be transferred to Indiana, it'll have to be transferred within that time frame.
All right, so what I can
And
tell
they'll
you,
have to accept the
he's not a
transfer.
good candidate for probation.
He's not?
No, he's not.
Judge, may I respond? Because I think
No.
that it is, well, it.
Where are we on
I
discovery?
think that is.
Where are we on
I
discovery?
I think, Judge, I feel like you don't want to hear the response, but it's important because this happens to people. What happened was I came yesterday, I wanted to get the Zoom link. I actually checked.
I don't give the
checked-
Zoom
they
link the
checked-
day before.
Yeah, they checked the docket.
I don't give the
They
Zoom.
said there was
It
no,
has Zoom reading right there. You see that on the docket? What does it say? Zoom.
I-
You know what that means?
but then the
That
court
means
issued a
that
bond
your client-
forfeiture.
I have not issued a bond forfeiture.
On the video.
I'm going to place you under oath. Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Excuse me,
All
ma'am,
right.
he has a right to remain silent. If I could understand the nature of the inquiry, I'd be able to properly advise him in that.
Yes,
regard.
I want to know if this is the first time he's seen police reports. This hearing was originally scheduled. No. The question is whether or not you were aware of the motion in limine, which you were, and whether or not you violated it in regards to violation of condition number 1. What you're trying to do with the witness, and excuse me, I'm going to have the witness step down. Did y'all even confer with the supervising officer before y'all reach y'all agreement? Did anybody talk to the person who was subpoenaed to be here?
I didn't subpoena.
Why would you all approach me? And I keep saying, talk to probation, and this is a contested hearing, and probation has brought this officer here who's needed back, looking at other people. You all need to go confer with her. Go confer with her.
Go have a seat, ma'am.
My other question, I guess, is if you're not doing this to cause the hardship, it obviously causes on all the attorneys and the defendants. Are you doing this for the YouTube? Because we don't have a record, right? Except for the YouTube.
Yes, here's the thing. You're to be back tomorrow at 9:30. You
Yes.
understand?
I guess that's fine. We don't need that paperwork because we've already got it in County Court 15.
All right, so here's the thing. County Court 15, which I think that judge is great. I think County Court 15 is great, but this is the 187th Judicial District Court. District Court takes precedent over misdemeanor court. I don't know why there was some sort of an agreement where people were like, oh, she's going to plead to the misdemeanor case, but then she's going to come back and plead to the felony case at a later date. We are taking this felony case now. Whatever County Court 15 is doing, that's their jurisdiction over misdemeanor cases. I'm in felony court. Felony courts takes precedent over misdemeanor court. That's what I'm telling you.
So we can't even get their names,
No,
even though the court puts their names on YouTube and leaves it
No.
out there.
and I did not put their names on YouTube. So let's be honest and truthful. I do not put the names or the faces of any jurors on YouTube. I know people like to say things, but that is not true. So here's my suggestion, and I'm not telling anybody how to run their case, but it appears that people keep asking me for things that I'm not giving them. So I want to be very clear. I am not giving the state or the defense 14 jurors names, addresses, and information based upon a hearsay statement.
I think that I'm supposed to be lead counsel with him, and somehow I have to check and see what's going on with that. So.
All right, so if he's on the system and you're not, it shows that he's on the system.
Yeah, but he's on it. We're co-counsel on it.
Well, no,
So-
he would have been notified.
No, Norma checked. He wasn't notified.
Well,
and
here's
his
the
office
thing.
checked.
This was set for August 20th, and there was a no-show by the defense attorney and Mr. Gober.
Yep, and Norma checked.
Okay, so let me finish speaking.
Okay.
All right, everybody, take a breath. Calm down. Let me finish speaking.
As the court may call this trial It was
Yes,
a very intense trial,
I recall the facts.
I know you called the
Mine's a
facts.
steel trap. I can tell you the entire case.
I know. And Judge, you and I, we've talked, not in terms of this case, but I know sometimes you think I talked a little more than maybe is necessary.
No, I do not.
But
It's okay if people want to be Charles Dickens and get paid by the word. I'm fine with that.
I got you. So I don't want to do that.
No, you
but-
can. I'm
okay.
serious.
May I speak to my bad?
Your attorney said that she did not want you to speak. The court has passed sentence.
I didn't know that I couldn't. I thought I had the whole time to testify. I thought she would.
I asked you if
All
you
right,
wanted
so,
a jury trial.
They're going to take you back. If
Can I
there's something
please-
else you all want to discuss, if you want to file a motion, you can file a motion and the court will hear that
Please
motion.
speak on my behalf. Can I please speak on my
I don't know what
behalf? I just want to testify. I didn't.
Patrick Washington. So we're going to proceed.
But the first, pardon my niece.
Mhm.
But the first motion was filed by the same conflicted district attorney.
Mhm.
And for that reason, I object to that proceeding on that.
You
Judge,
need
you're
to
aware
be
that every
here.
court starts at 9.
And you need to
I have
be
other
here.
cases.
And you need to be here at 9. So when your attorney is somewhere at another court, you know what ends up happening? Your attorney has made the choice to have you sit here and go to another court before
Well, that's
coming
not
here.
exactly true
You
because all of
understand?
those courts got
All right,
business
good luck to
accomplished.
you.
All
Thank
of us
you.
got
Thank you,
recalled
sir.
today.
Thank you,
Right,
sir.
Judge? So, I mean, what did we accomplish?
Have a nice
today?
afternoon, sir.
I mean, that's the reason I don't come to your court at 9, because I know in another court,
Sir,
something's
here's your
gonna actually occur.
Sir,
And they're courts of exactly the same
Sir.
jurisdiction.
right this way, sir.
Here today. I mean, the case would have been over on Friday.
Mr. Hilliard had a choice to make. He chose to go on his vacation.
Your Honor, the reason that there are vacation letters is because the courts have recognized that it is not a choice when somebody has a family, when they have non-refundable tickets, when they have plans that have been made for over a year's time. In addition to, he is not in a position where he could join them late because they are on a ship in the middle of the ocean. So he is not in a position that he could leave his family.
So you're telling me that cruises do not dock in different places?
They perhaps dock in different places, but he could not make half of the vacation with his family and was not willing to have his family go along without him. And that is why there are vacation letters. So the defense is asking for a continuance to allow Mr. Hilliard back.
Oh, that's going to be denied.
I understand.
Of the court and, being indigent, not being able to have a phone. I mean, I completely understand, not being aware that there are programs out there that can help you get a phone. I mean, obviously I shed light on that with
Well,
him
see, here's the
today.
issue with that. The issue with that is,
And I'm not a social worker, you know what I mean?
but here's the issue with that. I tell everybody who's placed on probation here, if there's an issue, they can come into court and let the court know.
I haven't filed it yet. It's ready to be filed. I can hand file it. Before I file it, I would respectfully ask the court to recuse
Okay,
on this case.
sure. We'll have a hearing on that.
Okay.
And that will be heard by Judge Hall. Ms. Ferguson, if you could call Judge Hall to see if he can have that heard immediately. All right,
Okay, and then the motion was a motion to recuse
okay.
on that.
Oh,
So
that's fine. Oh, counsel, you can file whatever motion you want to file.
So in that clip, Judge Boyd grills me for about 9 minutes, ultimately bringing the jury in, asking them if they recognize me, and then allowing me to sit. Only after I went through this, this performative, I think, questioning, and honestly with the intent to disparage or humiliate me, she finally.
Okay, now we can hear. All right, could parties announce for the record for the state?
Michael Villarreal, the state.
Oh, Brittany's here. All right, Brittany Sparks for the state, for the defense.
James Marad for defendant.
And are you Mr. Perez?
Yes, ma'am.
You're proceeding.
She just said, they don't send you to prison just because you don't have money. I don't have money, I need another attorney.
All right, let me
I need
stop.
another attorney.
Oh, no, just 1 second. Let me ask you this.
Yes, Judge.
Are you appointed or retained?
Appointed.
All right, you're appointed. So what that means is that the government, the state of Texas, the taxpayers, because you can't afford an attorney, had this attorney appointed to represent you.
Right.
So this is your attorney. If you want
Not
another,
representing me.
if you want another attorney,
Yes.
then you need to hire one.
How?
I have no idea. All right.
You don't have no idea.
Judge, may I present I explain the
The
difference?
time I was here before,
Mr. Bernal, can you have-
no, I need to explain.
So what I
It
would
was
like
the
to do right
same
now, Judge.
thing, burglary of a building, and it was dismissed. And
Yes.
now it's a repeater.
Let me ask you something, Mr. Bernal.
Yes,
You're Raphael Bernal?
yes,
What do you want to say?
I just said it.
No, what I need to know if they're true or not true. Do you understand?
Yes. Could I get a ruling on that objection though, ma'am?
It's denied.
Thank you.
Violated condition. Counsel, has your client been able to provide you with any defenses to this offense?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do, Your Honor.
Mr. Pettis, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, no.
Yes.
Speak on it a little bit.
Mhm.
There's a joint defense agreement in this case.
Mhm.
So when I say logistics, I'm referring to not only space, but also time. We're gonna have to accomplish a counsel table or an area that can accommodate 3 lawyer teams and their respective clients.
All right, so when you all say 3 lawyer teams, I can tell you all the space, turn around, the space that you see in this courtroom is the space that you will have. So if lawyer teams want to bring paralegals and everybody else, they're going to be sitting somewhere in the gallery. Well, I don't want to disparage any judge, but guess what? They're wrong. Because according to the law, according to that document that you all have just signed, the court determines the length of probation. Nobody else determines the length of probation. The court does. So if the state is asking for 8 years probation as the length, I can say, you know what? I've read the facts of this case. I think the person should only be on probation for 4 years or 3 years.